Good afternoon to all the viewers here at the Facebook page of the Ateneo Law Alumni Association. This is the second day of our web lecture series. I am Dean Marisol Animias and I am your host for today. The web lecture series is brought to you by the ALAI or the Ateneo Law Alumni Association, consistent with its mission to provide mentorship and linkages to networks of students and alumni in pursuit of professional and academic excellence. Today, we will be having the second module of the step-by-step litigation under the new rules of civil procedure. Last time, we didn't have a lot of time for questions, but we hopefully will have time for that. So please post your questions under this live lecture video anytime throughout the lecture. So, welcome once again, Justice Maria Filomena Singh, our lecturer for this topic. Justice Singh is an Associate Justice of the Court of Appeals. She's an alumnus of the Ateneo and a member of its faculty. She is, of course, a member of the Supreme Court Subcommittee of the Revision on the 1997 Rules of Civil Procedure. And just recently, Justice Monet played a very important role in the lives of law students and the law community, but that will be announced later on. So, welcome again, Justice Monet.
Thank you. Good afternoon, Dean. And good afternoon to all of you. Thank you for taking time out to join us today for the second module of our step-by-step litigation under the new rules in civil procedure. Today, our module will focus on trial up to judgment. So we're taking up rules 18 to 36 of the rules of civil procedure. Directly to the first slide, which will show you the flowchart of the conduct of pretrial and trial. Yesterday, I showed you the first flowchart, which consisted of all the steps from the filing up to the judgment, no? And then we proceeded to the steps and broke up the flowchart per event, no? So today, what you have on your screen again is the entire flowchart from the complaint to the judgment. But the next slide will show you what we're taking up to. In module 2, as we mentioned, we are going to start with pretrial. So we will discuss pretrial proper, court annex mediation, judicial dispute resolution, modes of discovery and intervention. And then we will have expedited judgments. You will have judgment on the pleadings, summary judgment, and judgment on agreed statements of facts. And then you have trial, where we will discuss trial proper, actually continuous trial now for civil cases, offer of evidence, and then demurrer to evidence. And then we will have the regular judgment, the judgment on the merits that we speak about, where we will discuss the period to decide, form and contents, and the entry of judgment. Okay, let's go to the next slide on pretrial. Again, I'd like to acknowledge, before I forget later on, and thank Attorney Lala Roses, who's helping me with the slides. And to repeat, I'm very privileged that I have a Harvard Law graduate assisting me in this presentation. Thank you again, Lala. Okay, so pretrial, from the date of the filing of the last responsive pleading or the expiration of the period to file the last responsive pleading, the branch clerk of court has 5 days only to issue the notice of pretrial. Okay, the notice of pretrial, you don't have to worry anymore what you need to put in it or include in it, because we have a form developed for you. Now, I am one who is known to be very, very fond of templates. I have been part of several groups that have developed templates for our e-courts, developed templates, and revised the civil procedure forms, first devised by then Judge Lucas Bersamin and his associates. No, so we revised them last year under the initiative of the University of the Philippines, and they are now with the Supreme Court awaiting approval. So hopefully they will come out soon to help us also in expediting our civil cases. And then, of course, we have the filing of the pretrials. The period now is 3 days before trial, as before. And then you have the actual pretrial conference. We call it pretrial proper. And then you have the issuance of the pretrial order, which is within 10 days from conclusion of our pretrial conference. And then you have court annex mediation. You will see that there is a shift here, no? Whereas before the court mediation, which is mandatory, happened before the pretrial proper, as well as the judicial dispute resolution, the committee now decided to do the pretrial proper first and then do the CAM and the JDR after. Okay, why? What was the reason? Well, the thinking is that we also do settlement. No, we try to we try to broach the idea of settlement to the parties during pretrial proper, and the common experience is that parties are more swayed or influenced by judges when they discuss settlement. No, so the thinking of the committee, the subcommittee, was that if the discussions of settlement are first had before the judge, then there may be more instances of settlement at that early stage. No, and then should pretrial be concluded, pretrial proper, without any settlement, then there will be court annex mediation as mandated, no, under the pertinent issuances of the Supreme Court. And then judicial dispute resolution. I don't know if it's showing on your screens, but I wanted that arrow pointing to judicial dispute resolution to be a broken arrow, because JDR now is no longer mandatory. No, it's now discretionary only in instances when the judge sees that there is still a possibility of settlement despite the failure of CAM. Okay, let's go to the next slide now. Okay, so let's discuss pretrial. When is it conducted? As I already mentioned, it has to be set, no, within 60 days, calendar days. As I mentioned, no, all days are now calendar days. Within 60 days from the filing of the last responsive pleading. The last responsive pleading could be the answer, or it could be a reply if there is an actionable document attached to the answer, and it could very well be a rejoinder if there is an actionable document attached to the reply. All right. And so, of course, we all know that pretrial is mandatory. I hope. Until now, I'm still hoping, no. But with the new rules, the revisions, I hope that we are forever rid of those. Pretrial is terminated upon agreement of the parties. Okay, so since our pretrial order also is now a template, no, so I hope no one will finish pretrial without going through all the required steps. Okay. And then the next slide shows you the notice of pretrial, what must be included in a notice of pretrial. And the very important addition here is that now you have to give notice of the dates, not just for the pretrial proper, but also for court annex mediation and judicial dispute resolution. No? Now, one lawyer asked me, Justice, why do we need to include a date for judicial dispute resolution when that is not mandatory? It's discretionary. So he said that sayang he put that date there. But I said, mas sayang if you don't put it there and then you need to do JDR and then you check your calendar but your calendar is already full. So hindi na po natin masusunod yung gusto natin na timelines, no? So by including these 3 dates already in your notice of pretrial, that is already a reservation, not just in the court's calendar, but also in the counsel's calendar, no? So if later on there is no need for CAM or for JDR because there was already a settlement at pretrial proper, well and good. There will be no prejudice to anyone. You just cancel those settings. Okay? All right. If you look at the next 2 slides, that is the template of the notice of pretrials. As I mentioned, you don't have to worry anymore about what you need to include. Andyan na po sa template. Of course, this is just a template. No, we're not mandating you to use this, no, word for word, but the important part should be in your notice of pretrial. No? So this is a guide to you, but if you want to use your own words, well, then do so. Just make sure that all the necessary contents are there. Okay, so and I have them there for you, like the relevant dates, as I said, for the three events, no, the pretrial proper, the CAM and the JDR, and then the pretrial brief, what should be contained in it, and then when do you file it. Okay, and next, what are the consequences of non-appearance depending on who fails to appear, and then representatives allowed, the rule is there, and then the last portion refers to the reservation of evidence, no, and the non-appearance and non-bringing or failure to bring the evidence. So all
now gives the necessary directives to the parties as to what will be done at the pretrial. Now, gone are the days when parties go to pretrial unprepared. Gone are the days when parties go to pretrial and asks the court, Your Honor, can I just bring my evidence at the next setting? Your Honor, I'm sorry, I did not bring the originals of my evidence. I have the photocopies here with me. Your Honor, can I just mark the evidence in the course of my presentation of my witnesses? No? So wala na pong ganun ngayon, because you will agree with me if you're a practitioner and if you are a judge that this is the great cause, is another great cause of delay for our trials. No, the markings, the comparisons, and then the stipulations in court, no, done in court in the presentation of a witness of all these evidences. No, kaya nga po, this time around, wala na pong ganon. Okay, now they're mandatory. You have to do this during pretrial, right? Now, the purpose of pretrial is still the same. Wala po tayong binago dyan. But if you look at the old provision under the 1997 rules, we removed the portion on the amendments, the feasibility of amendments to pleadings, no? And then the other one is regarding the suspension of proceedings. Why did we remove those two provisions? Well, regarding amendments, no? Because we want you to do all these things only as a matter of right, then within that period before a responsive plea is filed, and then by leave immediately when the necessity for it becomes apparent. Do not wait until pre-trial. There is no longer any necessity, unlike before, because all the evidence of your adversary will already be on the table even before pre-trial. So if you need to amend anything, you should do it as soon as possible time. That is this, the other reason, the other portion that was taken out is the, as I mentioned, the suspension of actions or suspension of the proceedings, because you know now that the rule is that suspensions are disallowed, no, unless there is a TRO or a WPI from a higher court, right? Okay, so let's go to the next slide. Okay, so there we added under paragraph F, no, the propriety of rendering judgment on the pleadings or summary judgment or of dismissing the action should a valid ground be found therefore, no? And that is something that should be utilized by our judges more now, no? Because unlike before, now at pre-trial, no, the judges would be the benefit of seeing the evidence, no? Per, uh, uh, literally or practically the entire evidence for both parties. So if you feel that you can already render judgment on the basis of the pleadings or a summary judgment, then by all means, please use this provision, no? And do not think twice about it. And then I'm very excited about letter G, no? As I mentioned already, these are the things that I used to do in my trial courts, and I know a lot of judges do this also. And these are that the judges have devised precisely because we want to eliminate the clutter during trial. We want to eliminate all that delay. So now it's been institutionalized. I'm very happy about it. Well, some of you might not be happy about it, but I'm really begging everyone to give it a try. I promise you the results will be to your liking. Okay, so what is this part that I'm so excited about, no? Now, during pre-trial, there is a record parties first to mark the respective evidence if they were not yet marked in the judicial affidavits. You know, this shows you that we will be reasonable, no, to a certain extent. Let's say that you submitted your judicial affidavits, but in the judicial affidavit, in the documents that you attach to your judicial affidavits, hindi nalagyan ng markings na exhibit A, B, C, or whatever. So this shows you that we can be reasonable in our interpreting rules, no? Because always, judges, please remember, what we want to do is to resolve their disputes on the merits, no, not on technicalities. All right. Okay. And then second, you after marking, you have to examine and make comparisons with the with your adversary's evidence, no, vis-a-vis the copies that were marked, no, kasi most of the parties do not want their originals to be marked, no, so they bring photocopies or reproductions. So we do our comparisons of the photocopies to the originals during pre-trial, okay? So wala na po yung provisional marking unless you are able to justify it talaga to the court. Like
it is impossible to bring it at pretrial because it's coming from, let's say, it's coming from another jurisdiction, from another country. Okay, and in those very extraordinary circumstances, we may allow you, but we will be very, very strict in applying this. Bring your originals to the pretrial and let's do our comparisons at pretrial. Of course, after you compare, number 3, you have to make stipulations. No, are these genuine reproductions or faithful reproductions of the original? And then hindi lang po tayo titigil doon. We will also proceed to make stipulations on the genuineness and due execution of these documents. No, so ito po gagawin na natin doon. We want to eliminate that story part of trial where you have to go through all those steps about identification and authentication of your documents. Okay, and then of course, we go to the next slide. Number 4, this is again very important, no? We will no longer allow any reservations of evidence. Very common, no? At pre-trial, counsel will request the court, Your Honor, can I make a reservation of evidence? Okay, whatever you're reserving. Your Honor, I reserve the presentation of other evidence as may be necessary in the course of trial. Oh, wow. Okay, so that's practically anything and everything, no? So no more, no? If you want to reserve evidence, this is the only way you can reserve evidence. Okay, if it's testimonial evidence, you have to give us the name or at least the position of the intended witness, the reserved witness, plus the nature of the testimony. Okay, and then second, if it's document or object evidence, then you have to give a particular description of the evidence that you're reserving. And then judges, please, if evidence is being reserved, like documentary or object evidence, no, you can already at pretrial assign exhibit markings to those reserved evidence. That is what I used to do para wala na pong confusion later on. Okay? And then, of course, letter G is just your catch-all provision. And then the succeeding slide just gives you a quote on the nature of pretrial, how it is mandatory, and what is its purpose. Of course, we are all aware what the purpose of pretrial is, right? We want trial to be less cumbersome. We want the real issues to be surfaced already so that the presentation of evidence will be focused on those issues. Okay, let's go to pretrial brief. Okay, so what are the contents? Basically the same as under the 1997 rules, but you will see that under letter C, now we clarified you have to state both factual and legal issues, no? Judge Jolo de la Rosa was very insistent on this, no? And I think this is a very good addition, no? Kasi we forget that there will be legal issues arising from the factual issues, di ba? Kasi we are so focused on presentation of evidence, and of course, presentation of evidence mostly centers on the factual issues, right? So nakakalimutan na natin ano ba talaga yung legal issue. So let us be focused on both, okay? So kaya ilalagay na po natin dyan, no? And then, of course, we just did some revisions to make it consistent with the requirements in the contents of a pleading, okay? And then the next slide shows you the failure to file a pretrial brief. Of course, we know that the failure to file a pretrial brief is going to merit the same sanctions as non-appearance at pretrial, okay? So for the plaintiff, then it will be a dismissal. For the defendant, then it will be the presentation of evidence ex parte by the plaintiff and ex parte judgment, no? So what is your remedy? If you file a pretrial brief and sanction was imposed on you, then you can file a motion for reconsideration on the ground of fraud, accident, mistake, or excusable negligence. Okay, now duty to appear at the pretrial. Okay, so the duty to appear at the pretrial falls on both the party and the counsel. Okay, if the party deems it necessary to send a representative, of course, in the case of juridical persons who are parties or which are parties in civil trials, then they necessarily appear only through representatives. So what we need is an authority, okay? But the authority, even for juridical persons, no? The authorized representative must be authorized for 3 specific acts, no? And that is, the first is to negotiate for and enter into an amicable settlement. So hindi pwede yung representative mo pupunta doon, and then when you discuss terms of settlement, the representative will say, Your Honor, I have to relay this, no, to the company or to the board because they have to approve it, then you are not authorized. That will be deemed as non-appearance kung ganyan, no? So you have to have power to enter into an amicable settlement. Second, you have to have power, no, to submit to alternative dispute resolution mechanisms, which will include CAM and JDR. Okay, and then the third is the power to enter into stipulations or admissions of facts and documents. Okay, all right, let's go to the next slide on pretrial. Okay, so we are now at the pretrial conference. Let's go to the next slide, Lala. Okay, so what is the effect of failure to appear at the pretrial? Well, the failure of a party to appear at pretrial, despite notice, of course, is a waiver of any objections to the faithfulness of the reproductions marked or the genuineness and due execution of documents. That is one additional sanction if you fail to appear at pretrial. Remember, now you're required to do all these things at pretrial. Okay, next slide, please. Okay, so if both the plaintiff and counsel are absent, then there is no doubt the case will be dismissed. No, that's the sanction. And if both the defendant and his counsel are absent, then there is also no doubt as to the effect. Then the presentation of evidence ex parte for the plaintiff will ensue. But what about if it's only the plaintiff that's absent? No, if the plaintiff is absent but the counsel is present, you have to ask yourself, is the authorized for the three purposes I mentioned for pretrial? If the counsel is not authorized, then you have to impose the same sanctions as if both the plaintiff and counsel were absent. But if the counsel is duly authorized for those things, then you can proceed even in the absence of the plaintiff because you have a representative in the person of the counsel. No? What about if it's the defendant who's absent? Then if the counsel is also authorized for pretrial purposes to represent the defendant for the three things I mentioned, no, then you can also proceed. Okay. What about if it's the counsel of the plaintiff who is absent? No? What is the remedy? Then you can do one of two things. You can either dismiss outright, no, for failure of the counsel to be present despite notice, because you know you cannot proceed in the absence of counsel because counsel is officially representing the plaintiff, no? Or this is my advice, no? You can issue a show cause order for the non-appearance. Give the counsel 24 hours or 48 hours, depending on the mode of service that you will employ, no? To explain his non-appearance, no? And if the excuse is not valid, then that's the time you dismiss. You may say, I thought we want to, we want to eliminate clutter, we want to be fast, no? If you do this, if you issue a show cause order first, you might be avoiding lengthier proceedings because for sure there will be a motion for reconsideration with an explanation of the reason for the absence, then it will amount to the same thing. So by issuing the show cause, you are actually saving on time, okay? Now, what about if it's the counsel for the defendant who's absent, no? So you can already immediately set the ex parte presentation of the plaintiff's evidence, but in the same order, you direct the counsel for the defendant to show cause, no, for his non-appearance, no? And if the excuse is valid, then you can recall your order setting the case for ex parte presentation of evidence. But if the excuse is not valid, then you can proceed with the ex parte presentation of plaintiff's evidence and thereafter render judgment. Okay, let's go to the next slide. Is there a default for non-appearance at pretrial? No? In the 1997 rules, wala na pong default for non-appearance at pretrial. We got rid of that. We got rid of that concept. So the only time defending party is going to be declared in default is when he or she or it fails to file an answer within the time prescribed. Okay. So, but failure to attend at pretrial is considered the party is considered as in default, no? So kasi po as in, kasi the effects are the same, no? So you are not entitled to participate anymore in the subsequent proceedings. Of course, you will still be entitled to notice, no? Including notice of judgment. All right, let's go to the next slide, please. What is the effect of your failure to bring evidence at pretrial? As I already mentioned, no? So this will be tantamount or equivalent to a waiver of the presentation of such evidence. Okay, so may sanctions din po. If you do not appear, you waive your right to object to the genuineness and due execution, also to the faithfulness of the reproductions. But if you fail to bring your own evidence, then you can no longer present those evidence. Of course, all of these rules, no, have to be tempered by a reasonable interpretation. Kung meron po kayong justifiable cause, hindi naman po kami ganun ka-unbending, no? All our judges are trained to apply the rules liberally and with reason. I'm back. Lala, we are on our slide on the guidelines to be observed in the conduct of pre-trial. I'm sorry, there's a thunderstorm here and it's raining quite hard, no? So, but I will reconnect. Every time you lose me, please bear with me and I will try to reconnect. Okay, so we're here. I'm just reminding you of a 3-1-09 of the SC, the guidelines, no, in the conduct of pre-trial and preliminary conference. So the question now of the judges is, are we doing away with the preliminary before the branch clerk? The short answer is yes. Okay, so we thought that we now do everything in the pre-trial proper. Okay, this should not the judges and the clerks from doing the work together. No, during the pre-trial proper, the branch clerk can be present and do all the markings. The judge does not have to be the one to supervise all of that. Everything will now be done during the pre-trial. Okay, and minutes also supposed to be taken. Okay, now let's go to the next slide: judicial affidavits and pre-trial. Okay, so just again a reminder: these are the provisions of the judicial affidavit rule on judicial affidavits. No, I've been asked several times already. Do the revisions in do the present revisions to mean that the judicial affidavit rule has been superseded or repealed in its entirety? My answer is no. Okay? Remember, the judicial affidavit rule is a rule was promulgated by the Supreme Court. Okay? Now, the revisions, of course, again, are promulgated by the Supreme Court. Now, the judicial affidavit rule, or I should say the revisions, have a repealing clause for all those prior rules which are inconsistent with the revisions. But the judicial affidavit rule is not inconsistent with the present revisions. In fact, the judicial affidavit rule supplements the present revisions because the judicial affidavit rule is the specific rule. It has details which are not carried over in our present revisions. So you can also still harmonize the two. So you can fall back to the details of the jar if you do not find it in our revisions. Okay. So here, just reminding you of how you mark your documents when you append them to your judicial affidavits, and how your affiant should also identify them in their judicial affidavits. Okay. All right. Of course, you all that under Rule 7, Section 6 on contents, judicial affidavits must now be attached to our initiatory pleadings. Okay, let's go to the next slide, please. Again, another provision, Section 2 of the Judicial Affidavit Rule on object evidence in judicial affidavits. Just as a reminder for all of you, we don't need to go through it in detail. And the next slide shows with the judicial affidavit rule, no? I have this here for you just to remind you, because there are questions, no? What about if I'm able to append, no, one judicial affidavit because my witness, because of the lockdown, there are no flights, no, I was unable to, etc., etc., and my period to file the answer with the judicial affidavits is already about to expire, no, and I've used up my extension, no. no, we are trained to apply the rules with reason and fairness, with the ultimate objective of resolving your conflicts on the merits, okay? So if you look at the judicial affidavit rule, you have it on your screen, there is room for one submission, okay? It's my view, it is my view only, my personal view. I hope the other members of the committee share it, no? That the one late submission rule under the JAR is still applicable as long as the party is able to justify the delay, no? Plus, there will still be that payment, no? Although in the past, I've always spoken out against collecting that payment. Okay. All right. Let's go to the non-compliance. Still the continuation on the next page. That's just the one late submission rule. Okay. Let's go to the next slide. Okay. So now we're moving on to the pretrial order. Okay, so the next slide again. So now we're at the issuance of the pretrial order. Judges are supposed to issue the pretrial order within 10 days from the pretrial's conclusion. Okay, and these are the contents in the succeeding slides. You'll see the contents of the pretrial order, what must be included in the pretrial order. And you will see under letter G, okay, the case flow chart, okay, to be determined by the court, which will contain the different stages of the proceedings up to the promulgation of the decision and the use of time frames for each stage in setting trial dates. Yan po yung natin ngayon, no? Started yesterday. We are doing this step, stage by stage, phase by phase, and I'm giving you all the timelines that you need to comply with. Okay, so that is essentially what the case flow chart is going to be in your individual cases. All right, and then letter H has reference to the one-day examination rule. What is a one-day examination rule? Which was first set in the AM that I referred to earlier, 03109 of the SC, no? One-day examination rule simply requires that if a witness is presented, the testimony of that witness should be complete in 1 day or day, no? Because nangyayari po sa atin, we are all exhausted because of our piecemeal trials, no? Because of the volume of cases, the number of cases in the calendars of our trial courts, piecemeal trial has become the norm, no? And so the one-day examination rule under these new rules is a reminder, no, that let us set the testimony of witnesses only on 1 day to avoid delay. Not only that, to avoid inconvenience to all the parties, plus also it makes our work harder to keep on reviewing and because by the time we call the witness again, we would have forgotten what was already tied on at the preceding date. No? So the one-day examination rule, as much as possible, please comply with it. And then, of course, the other one is the most important witness rule. This is to prevent the presentation or the inclusion in the list of witnesses of merely corroborative witnesses. No, when I was a trial judge, I would allow only one corroborative witness, no more than one, because we don't need that. It's not the number of witnesses, but the quality of their testimony that matters. Okay, and then letter I. Okay, a statement that the court on the pleadings or summary judgment, as the case may be. This is new, and this is part of our expedited judgments. No, so in the pretrial order, if the judge deems it proper to render judgment on the pleadings already or summary judgment, it must already trial order. Okay. Then the next slides will just show you a template of the pretrial order, which we have already prepared for all our judges and our branch clerks to use. Again, this is just a guide for you. You can employ your own language and style. We want you to even necessary parts must be in your pretrial order. Okay, the important parts there are the warnings and the caveats, including regarding postponements. Okay. Okay, now go to pre-trial. I'm sorry. Let's go to trial proper, okay? I'm sorry, court annex mediation. I couldn't see very well my here, okay, because it's called. Okay, John, everyone is familiar with court annex mediation. So this now will happen after pre-trial proper, and I explained to you the reason for it. it. And now we have limited the time to 30 days maximum, okay, without further extension. And if court annex mediation fails, what happens next? No, the judge. We will go to the next slide. To judicial dispute resolution, the judge has an option. No, uh, if he or she believes that settlement is still possible after failure of CAM, then the judge can refer the case for judicial dispute resolution. Okay, now judicial dispute resolution will now be conducted not by the original judge handling the case, but by a different judge. So in multi-sala courts, the judge handling the case will refer it to the OCC for reassignment just for JDR purposes. Okay, so it will go to a different branch. And then if JDR fails, that case will be returned to the original judge. Unlike before, the original judge does the JDR, and if there is a failure of JDR, the case is unloaded. Okay, so that is no longer. We found that to be really not conducive to speedier disposition of the case. Not only that, um, it brought about a lot of questions regarding unloading failed JDR cases, okay, among the judges. So now we have changed the rule, and we hope that this will speed up our processes. Okay, now JDR is only going to be done within a fixed period of 15 days, no more, no less. All right. Okay, and then the next slides will show you just a comparison of our amendments regarding JDR and then the requirements, and then under our present rules. No, so I already mentioned the JD is now no longer mandatory, and it's going an index period of 15 days. And of course, just as a reminder, all the proceedings under CAM and JDR are confidential in character. Okay. Now let's go to the effect of failure to appear during CAM and JDR. Okay, it will be equivalent to non-appearance pre-trial. That because CAM and JDR are parts of pre-trial. They are considered as part and trial. So if you fail to appear at CAM, if you fail to appear at JDR despite notice, we impose on you the same sanctions as non-appearance at pre-trial. Let's go to the next slides. The next slides, we will not go through them in detail. These are the modes of discovery. You have from Rule 23, depositions pending action, and then you have Rule 24, depositions before action or pending appeal, and then you have interrogatories to pass under Rule 25, and then you have adjournment by the adverse party under Rule 26, and then Rule 27, of course, is production or inspection of documents and things, and Rule 28 is physical and mental examination. Why did I include this? No, I have several slides regarding each of the modes of discovery, but this is for you to refer to at your own leisure. Okay, I'm not going to. The committee did not touch on any except to revise Rule 23 and 25, whereas before there is a portion, there is leave of, and there is no. Now it's always upon ex parte motion of any party, meaning it's become non-litigious at of the proceeding. Okay, so yun lang po ang change dyan. Otherwise, they remain the same. So all I wanted to do to put this here is to show you where modes of discovery fit in the process. You may ask, meron pa bang utility at modes of discovery considering that evidential tayo ngayon, no? In the inventory pleadings, all the evidence, including judicial affidavits, are already attached. So the answer is yes. There can be new matters that the plaintiff was not aware of until the plaintiff received the answer, no? And which the plaintiff may find the need to resort to modes of discovery or vice versa, no? So that is why the modes of discovery are still there, no? But my experience in all my years in the judiciary is that both litigants and judges are wary of the modes of discovery. Very, very few instances are the sanctions imposed, no, for non-compliance or for failure to answer, for example, a request for admission. When I was a practitioner, I would always resort to admissions, not a request for admissions. Immediately after I file after I file my pleading, I would already be preparing request for admissions. And more often than not, no, they will fail to answer in the way that the rules require them to, no? Like it has to be verified, has to be by the party, no? And has to be within a period of 10 days, no? So pag ganun, dapat magmo-motion na rin ako sa court to deem those matters admitted. Na-frustrate ako. Bihira yung mga court na nag-grant ng ganung motion, no? So, lagi nila sasabihin, let's just resolve your case on the merits. But Your Honor, di ba, makikipag-argue ka. Pero I guess it's because of our unfamiliarity, no? People are always afraid of the things they're not familiar with. No, a good example would be technology, no? But eto, pag pinilit mo, like now we are all forced to use technology to continue our work, pinag-aaralan, no? And that is the reason why I included these slides here, no? Please study them at your own pace. Hindi po sila complicated, and these modes of discovery can help you. Okay? Isa lang ang limitation. Lahat niyang modes of discovery na yan, isa lang ang limitation, relevance. Okay? Ayaw lang namin fishing expedition. Ayaw ng rules ng fishing expedition. Kaya nilagyan natin ng restriction lahat yan. There has to be that condition of relevance or pertinence. And of course, if you take the deposition of somebody, whether it's through oral examination or written interrogatories, hindi automatic bound ka na, okay? That you need to introduce that deposition already kasi ikaw nag-move for it to be taken. Hindi po yun ganon, no? You can use it or not use it, no? So kukunin yan, i-present pa sa court. It has to be admitted like any other evidence, no? Not it's just not the fact of taking na automatic na po evidence na sila sa case natin. Hindi po ganun yun, okay? So these are just modes of discovery. Once you have discovered what you are looking for, you still need to present it in court in the way that the rules on evidence require us to, okay? So we will skip these parts now, Lala, because as I already mentioned, this is really just for you to do at your own pace, okay? Now, very quickly lang, ano yung difference between letters commission and letters rogatory, no? Yung letters commission po, yun yung sa local. If, for example, we allow the deposition to be taken, we issue a letters commission, let's say to the notary public, before whom the deposition will be taken, no? Pero pag letters rogatory, yan request natin sa foreign jurisdictions, no? Maybe it can be to a court, no? For the taking of that deposition. So yun lang po yun. Just some terminology for you. And then I have comparisons there for you between oral examination and written interrogatories. Comparisons also between depositions pending action and depositions before an action has actually been commenced, no? So pwede po tayo mag-perpetuate ng testimony, tawag natin dyan, no? For example, you're afraid that your witness might not be that healthy and might pass away even before you could complete your evidence so that you can file a complaint or a petition, then you can already resort to deposition taking before the action, okay? All right, and then the sanctions are also here for your failure to comply with the rules, all right? Okay, so now, Lala, we will go to our intervention, okay? That is the next step in our process. Intervention, who may intervene, okay? Okay, so I hope that find time to go through these slides on the modes of discovery, okay? So now we go to intervention. Intervention is allowed at any time before judgment, no? That is still the rule. Wala pong change sa rule natin. But the question now is who may intervene? Also no change. It has to be someone with an actual legal interest in the subject matter of the litigation, no? Hindi po pwede contingent, hindi po pwedeng future interest pa yan, no? That's the only thing that I want to remind you about, no? And of course, the discretion in allowing an intervention remains with the court. And the primary consideration is that an intervention will not unduly delay, no, the resolution of the case as between the original parties, no? So ang lagi pong iniisip natin pag may joinder tayo, pag meron tayo intervention, no, pagka pag kami alternative or additional causes of action tayo, we always think about the original issue, the original controversy between the parties and the original parties. We don't want any delay, okay? So of course, an intervention is just supplemental to the existing case already, no? It's ancillary. It's not the main. It's not the main case. Okay. And then, well, what are your pleading intervention? You have your complaint in intervention. If your interest is in the success of the plaintiff, then you are going to file a complaint in intervention. But if your interest is in the success of the defendant, it's going to be an answer in intervention. All right. Okay. So now let's go back to our flow chart. Now we are at expedited judgment. Okay, so we're done with there we go. Now we're at expedited judgments, okay? Now, this is new, no? Should there be no more controverted facts, no more genuine issue as to any material fact, or an absence of any issue, or should the answer fail to tender an issue? The court judice to a party moving under Rule 34 for judgment on the pleadings or Rule 35 for summary judgment. The court to proprio, okay, include in the pretrial order that the case is submitted for summary judgment or judgment on the pleadings without need of further position papers or memoranda from the party. In such a case, the judgment will be rendered within 90 calendar period. Hindi po natin iibahin, no? That's fixed in the Constitution, no? So, part also is the last sentence there, the order of the court to submit for judgment pursuant to this will not be subject to an appeal or a certiorari petition under Rule 65. Okay, so ito po yung minention ko kanina in your pretrial order. If you find that the conditions for a summary judgment or for judgment on the pleadings are present, then you can already, judges, you can already include in your pretrial order that you are submitting the case for judgment on the pleadings or for summary judgment without need of further memoranda. Okay, so iyon po yun, and then no appeal from that order, neither is a Rule 65 petition allowed. Okay, now what is a judgment on the pleadings? Wala naman po tayong pinalitan dyan, no? Rule 34 is the same. But just to reiterate, it is when the answer fails to tender an issue or otherwise admits the material allegations of the plaintiff's pleading, the court then may direct judgment on the pleading, no? So may exception po tayo dyan, yung mga nullity at saka annulment cases natin. But judgment on the pleadings is you focus on the pleadings, okay? You do not go beyond it. Do you consider the evidence attached? Like now, kasama na po ngayon sa ating complaint, saka sa answer natin yung judicial affidavits, no? Naka-append na po doon, no? Judgment on the pleadings is literal, okay? So, doon lang po kayo magpo-focus doon sa pleadings nila. If reading the pleadings, there is no genuine issue between the parties, no remaining material issue between the parties, then judgment on the pleadings is proper, okay? Next slide, please. Now, the court may motu proprio or on motion render judgment on the pleadings. As I said, motu proprio, you will include it in your pretrial order, but it can also be via a litigious motion of a party, no? In which case, then you must follow the rule on litigious motions, okay? Now, any action of the court on a motion for judgment on the pleading shall not be subject of an appeal or petition for certiorari prohibition or mandamus. Okay, let me just clarify this. For example, the court denies the motion for judgment on the pleadings, no? Or denies the motion for summary judgment as a litigious motion, no? Ang sabi po ng rule natin, you cannot file an appeal. Okay? Hindi nga pwedeng mag-appeal kasi di na sabihin tutuloy po tayo sa trial. Okay? So wala pa pong appeal kasi that's an interlocutory order. Alright? Pero wala ring Rule 65, no? Tinanggal po namin. Kasi as I already mentioned yesterday, paulit-ulit, we want less clutter. We want less interlocutory incidents being brought up, no, and delaying the main case. So, bakit po gano'n? Nawalan na ng remedy ang parties? No, that is not true. You still have a remedy. You wait for judgment on the merits, then you elevate the case on appeal, and you assign that as an error of the trial court. Okay? So, hindi po kayo natanggalan ng remedy. What about if na-grant yung judgment on the pleadings or yung summary judgment, kung na-grant, ibig sabihin judgment yon, di ba? So that means the remedy is appeal. Okay? It's not 65. Okay? Let's go to the next slide. Okay, so that's just a reminder. When your motion for judgment on the pleadings is litigious, this is what happens. You need proof of service. Okay, you can serve through personal service, accredited courier, or registered mail or electronic means. Alam nyo na po kung ano yung proof. We discussed that yesterday. Okay, second, the opposing party, yung adversary mo, automatically has 5 calendar days from receipt of your motion to file an opposition. No, do not wait for the court to direct you to file opposition. That will not come. 5 days mo. Okay, so from your receipt of the motion, you need already to file an opposition, count 5 days. No, and then from receipt of the opposition or lapse of that 5-day period to file an opposition, the court must resolve the motion. 15 days lang po ang bibigay sa atin, okay? Ngayon, yung number 4 po, yan po yung tinatawag nating discretionary hearing. The judge has the power to set a summary hearing on the motion if the judge feels that it is necessary. Wag naman po sana nating gamitin lang po natin to sparingly kasi judgment on the pleadings po naman yan. Nasa pleadings na po talaga. So kung may pa po tayo i-clarify dyan, hindi po dapat mag-judgment on the pleadings, di ba? Kasi ang judgment on the pleadings when there is no more genuine issue between the parties, okay? Or no issue of fact remaining. So kung nakikita pa pala kayong issue, baka po kailangan i-deny natin yung judgment on the pleadings. But as I said, this is within your discretion, okay? All right. What is a genuine issue? There's a definition from the case of Iloilo Jar Corporation in the next slide, no? It means one that requires the presentation of evidence, no? Kaya nga po, kung may genuine issue pa, hindi po tayo pwede mag-judgment on the pleadings, all right? The succeeding slides also, slide also refers to a definition of what judgment on the pleadings is and when it is proper. Okay, and then now let's go to summary judgment. No, so summary judgment happens when the movement, it can be any claimant. No, it can be the plaintiff or the defendant, but anyone who has raised a claim before the court can move with supporting affidavits, depositions, or testimony for summary judgment. No, when there is no genuine issue remaining between the parties. Okay. And then the next slide shows you a quote again as to the nature of summary judgment. Okay, so pareho lang po yan. And then we go to the rule itself, summary judgment for the claimant. You have to make that motion as a litigious motion if the judge does not motu proprio include it in his pretrial order. And then in the same manner, you have 5 days. If you're the adverse party, you have 5 days to oppose it. And the court will have 15 days from receipt of the opposition or lapse of the period to oppose to resolve the motion for summary judgment. No, and then in resolving, we must be reminded the same rule under judgment on the pleadings that a denial is not subject to appeal. It's not subject to a Rule 65 petition. The remedy from a denial of a motion for summary judgment is an appeal after judgment on the merits where you assign as an error the denial of your motion for summary judgment. Okay, so let's the next slide now. Partial summary judgment, that is possible, no? If summary judgment is rendered only as to one issue, no, and there is an issue which requires the presentation of evidence, this rule provides that the court must direct that such further proceedings be conducted, no? So syempre po, kasi there is need for presentation of evidence as to some remaining issues, then the judge must not forget that remaining issue for trial, okay? And then what is the papers that's in the next slide? That's just for you to look at your own leisure. It's still the same. And then bad faith is punishable by contempt. That is na po new, no? Now, on the next slide, we have the distinction between judgment on the pleadings and summary judgment, no? Okay, so simply stated, what distinguishes the judgment on the pleadings from a summary judgment is the presence of issues in the answer to the complaint. When the answer fails to tender any issue, then it does not deny the material allegations of the complaint or admits them, then that is judgment on the pleadings, okay? But summary judgment is when there is summary judgment requires the presentation of affidavits and even oral testimony, the claim, no? But just by looking at those supporting affidavits, decisions, no, the court can already read, no? So yun po yung distinct nila. Yung judgment, it literally you are limited to the pleadings, but summary judgment, meron tayong affidavits, depositions, etc. Okay? All right. Now, the next slide shows you another provision which we have not used, no? Well, no? Ito po, nandun na po yan sa ating rules, no? Pero hindi natin nagagamit. It says that the parties to an action may agree in writing upon the facts involved in the litigation to submit the case for judgment on the facts agreed upon without the introduction of evidence. Okay? So ito po, based on admissions naman, no? So, kasi, or stipulation. So kung halimbawa, pre-trial, nagkaroon na po kayo ng stipulation sa issue for the court to try, no? You can already mutually submit the case for judgment by consent, no? So ito po yun. Although actually I've decided maybe 2 cases on the basis of this after we did pre-trial. All right, so now let's go back to our flow chart. This is the flow chart for continuous trial now, no? So you end with pre-trial. You issue the pre-trial order after 10 days from the conclusion of your pre-trial, and then you set the plaintiff's presentation of evidence, okay? And then the plaintiff's presentation of evidence commences within 30 days from the termination of pre-trial. So dapat po, from conclusion of pre-trial, 30 days, initial presentation of plaintiff's evidence na tayo. Now, depending on the number of witnesses to be presented, okay? You can assign a maximum of 3 months, no? 3 months or 90 calendar days to the plaintiff to complete his or her or its evidence presentation. Maximum po yun, okay? Ngayon, kung isa lang ipepresent niya, yung sarili lang niya, then you will probably just use what? Less than 30 days. You'll probably use half a month and matagal na po yun, okay? And then after that, of course, we go to the formal offer. And we know from our revision of the rules on evidence and already from the judicial affidavit rule, no, that the offer of evidence now has to be oral. Later on, we'll discuss that, no? And when do you do your oral offer of evidence, no? Under the judicial affidavit rule, you have to do your oral offer of evidence on the day of the last presentation of evidence, okay? So, you may say, hindi ko naman po alam na mako-conclude yung evidence ko. And why not? Diba? We have a schedule of trial. You know when you will be presenting your last witness. So, you better be ready with oral offer on the day of your last presentation. Okay? So, we don't want to waste time anymore. Ang dami pong oras na nauubos sa kakaintay sa offer of evidence in writing. At hindi pa ho yun. Hintayin pa rin yung comment in writing, no? So that's why we thought it wiser, no, to make all or offers of evidence oral. And the objections are oral, okay? All right. So then, after that, the word to evidence, no, enters, no, into the picture. Kasi evidence presentation ng plaintiff, now the defendant has a chance again for an expedited judgment without having to present any evidence if the defendant feels that the evidence presented by the plaintiff does not come up to preponderance of evidence, then the defendant may file a demur to evidence under Rule 33. If it's granted, then the case is dismissed. That's the end of it, okay? But if it is denied, then we proceed to the next step, which is the presentation of defendant's evidence. Now, the presentation of defendant's evidence, the maximum allowable period also is 90 calendar days or 3 months, no? And in the same manner, it will depend on the number of witnesses to be presented, okay? Pero maximum na po yung 90 calendar days. And then And then we proceed to offer of evidence for the defendant, same rules. And then if there is a third-party claim, no, like a third-party complaint, or if there is a permissive counterclaim or a cross-claim, dyan na po papasok yan, no? We are also allotting a maximum of 90 days or 3 months for these other claims. Okay, so additional po yun, no? And then the last step there will be rebuttal evidence. If either or both parties want to present rebuttal evidence, binibigyan lang po natin sila ng maximum of 30 days. Pareho na po yan, not to exceed 30 days. Okay? So if you total all of these up, no, all these time frames, no, and all these stages, kung wala po tayong third-party complaint, etc., you will only consume a maximum of 180 days. Maximum na po yun, okay? And that's 6 months. Now, if you have those third-party complaint and you have rebuttal evidence, ang maximum na po natin is 300 days or 10 months, no? No, if you think about it, kung makomply po natin to, naku, nakakatuwa po. Eh, sana makomply po natin to. There is no reason for us not to be able to comply with this, okay? Now, let's go to the next slide, the order of trial. Of course, subject to the provisions of Rule 31.2, that's the rule on trial, on periods. And unless the court for special reasons otherwise directs, this will be the flow of our trial. And I already mentioned this to you. First the plaintiff, then the defendant, then the third party claimant, fourth party, etc., the count, the cross claimant, and then rebuttal evidence. Okay? And then let's go to the next slide, the strict observance of the trial schedule. We are reminding lawyers that if you ask for a postponement, and if it is justified, we will grant it, no? And I will mention the reasons later on for the motion for the valid grounds for postponement. But if it is granted, we will not give you extra time to complete your evidence presentation, okay? Because at pre-trial, we are setting the dates, we are preparing our flow charts stage by stage. Okay, so if you have, for example, 3 witnesses, and let's say the court gave you 5 days to complete your evidence presentation for 3 witnesses, okay? If you own 1 date, so that leaves you 4 dates. We will not grant you an extra day, okay? I hope that's clear, right? Okay, let's go to the next slide. Again, just I did it as a chart so you can easily see it, okay? So, but we've already discussed that. Let's go to adjournments in general. Okay, next slide, please. So in general, no, the court does not have any power to adjourn trial for a longer period than 1 month for each adjournment, okay? No, but I will tell you, when I was in MTC in Quezon City, my docket was over 5,000 cases, no? And my calendars would exceed 70 every session, and I had settings in the mornings and in the afternoons. Of course, these were more of them were criminal cases, majority. Konti lang po yung civil cases ko. Pero yung adjournments namin matagal, no? As in, sometimes the next setting is 6 months after, no? And that is taking into consideration of availability of the PAO and of the fiscal, no? And of course, the number of cases, no? So medyo mahirap po talaga noon sa MTC Quezon City. But now I'm very happy to hear from our judges na considerably reduced na yung dockets nila, no? Very happy for that. Okay, let's go to the next slide. Postponements. Ito na po tayo, no? So postponements now are generally prohibited. Ang presumption po namin ngayon is postponement is always intended for delay. That's now our presumption, no? So you have to justify to us why we should grant you a postponement. And you can only justify it under 3 grounds. The first is force majeure, the next is act of God, and the third one is duly substantiated physical inability of the witness to appear and testify, no? But I will qualify this again. So there is some imprecision, I think, no, this is my opinion, but I think we should include the physical inability of the counsel also, no? So we have to be reasonable even if the witness and the party are present, but if the counsel falls ill and is confined in the hospital, then I don't think we should be unbending, no? So kaya kailangan po ang interpretation natin dito, judges, no? So isama po natin yung physical inability of the counsel to appear, no, for some substantiated reason. Okay? So, yun po. And then, of course, as I already mentioned, other than this, your motion for postponement will be deemed prohibited motion. Okay, so the next slide, if the ground, this is the provision in the 1997 rules, no? At hindi naman po ito na galaw, no? Ito po yung if your postponement is due to an illness or a medical reason, ang hinihingi po doon is an affidavit, okay, or a sworn certification that the presence of party or counsel is indissolvable. Okay, that's number one. That's the first condition. But the second condition, the character of the illness is such as to render that person unable to attend. And so the non-attendance is excusable. So karaniwan po, ang pre-present po sa atin ay medical certificate. Okay? So the medical certificate addresses the second part. Okay? That the character prevents the appearance and so it's excusable. Pero wala po yung first condition. Hindi po nasasabi doon na the presence of that party or counsel is indispensable. Okay? So you may say, ay, given na lang yun, no? Pero I'm just pointing out no, that this is the requirement of the rule and we largely ignore it. Hindi po tayo nagko-comply dito. Okay? So please take this into consideration henceforth. Okay? Now, the next slide only refers to the postponement fee and the official receipt that we will issue to you when you ask for a postponement. No? Huwag po natin kalimutan, the courts not act on your motion for postponement if it's an allowable ground. Ha? Otherwise, as I said, prohibited motion yan. We will not act on it kung hindi po binayaran ang postponement fee namin. Okay? All right. Now, effect of postponement without the presentation of the scheduled witness will proceed, no? In the absence of that party, because his absence is inexcusable, and that party will be deemed to have waived his participation particular date, whether to cross-examine or to object to certain questions on additional direct, etc., etc. Okay? And then, postponements do not affect the trial schedule. I already mentioned that to you. Okay, now let's go to suspension of actions. Okay? The suspension of actions will be governed by the Civil Code and other laws. No, under the Civil Code, you have Article 2030, which refers to settlements or compromise. No, but I'd rather discuss with you Supreme Court Circular numbered 7A92. Circular 7A92. This is the circular of the Supreme Court on archiving of cases. No. In particular, in civil cases, the Supreme Court allows archiving, okay, only, number one, if there is settlement between the parties. But the period to archive is a fixed 90-day period, okay? So automatic, after the lapse of 90 days, the case must be included again in the active calendar of the court, okay? Second is, when there is an interlocutory incident in a higher court, and the higher court has issued a temporary restraining order or a writ of preliminary injunction. No? So that we are aware of. That is carried in the revision we have now. Now, the third one is when the defendant, okay, without fault on the part of the plaintiff, could not be served with summons within 6 months from the issuance of the summons. No? Ito po ang nagiging cause ng delay sa civil cases natin. Nakikita ko to, when I was a trial judge, nakikita ko, every time I do my semestral inventory, nung bago ako, nakikita ko, ang dami po naming cases na nasa archive, no? Kasi ang mga judges, the lawyers ask to archive cases when they cannot serve their defendants because they cannot find them. So mali po yun, kasi po, ang sabi po sa circular natin on archiving 7-92, you can only archive for non-service of summons if, number one, it is without any fault on the part of the plaintiff, and second, 6 months must have been or must have lapsed from the date that the summons was issued. No? So, kung meron pa pong recourse like service by publication because the whereabouts of your defendant are unknown, okay, under Rule 14, Section 16 now, used to be Section 14 under 1997 rules, no? Eh, hindi po, may fault po ang plaintiff doon, di ba? Kasi meron siyang failure to prosecute. So, kailangan po, we use this in that context. All right? Okay. Okay. Now, let's go to the hearing days and calendar call. Pareho pa rin po, no? Of course, there are some changes because of the ECQ and the MECQ and the GCQ. Okay? So, next week, June 1, GCQ na po tayo sa National Capital Region. Good luck to everyone, and I wish everyone will be safe and will remain well. Okay? Ito po yung mga rules natin. We put it in table form so that you can easily refer to it. Can we go to the next slide? The table, okay? So it shows side by side our Supreme Court's issuances on, well, for ECQ, the Enhanced Community Quarantine Areas, for the General Community Quarantine Areas, and for the Modified and Enhanced Community Quarantine Areas. Na po yan. So magiging GCQ na tayo sa NCR June 1, starting June 1, no? So ang rule po sa GCQ is physically open but skeleton staff to assist the judge. Yun po daw ang rule sa GCQ, no? But please, although we say physically open, we are discouraging you from going to court for follow-ups or verifications or filings. If you can do them electronically, please do them electronically. If you can call us, just use our hotlines. No? Yun po ang aming ine-encourage para minimize po natin yung person-to-person, face-to-face contact. Of course, kung wala po talaga kayong electronic means, kung wala rin po kayong telepono, wala po tayong magagawa. We will just observe the proper physical distancing here, okay? And then, we are open Monday to Friday, 9 a.m. to 3 p.m. Yan po ang nakalagay para po sa trial courts natin to, no? But for the Court of Appeals, at least, I can tell you we are open regular hours from 8 to 4:30 p.m. Okay, next slide, please. What about the filing of pleadings? Ano po? Well, please remember that if you have deadlines, no, for filing of pleadings or other documents with the courts, if the deadlines fall within the period of the ECQ, the MECQ, the GU, automatic po may extensions kayo, 30 days, depending on the number of times that your place or your judicial region has been placed under those quarantine rules, no? So meron po kayong extension. Ganun din po naman ang justices natin. If the judge or the justice has any work falling due on any of those periods na naka-quarantine po tayo, binibigyan din po tayo ng extension, okay? But can you continue to file papers with the courts? Yes, you can continue to do so. But as I already mentioned, we are encouraging electronic filing if feasible. If not, please, we will observe the proper physical distancing, okay? And please protect yourselves. Do not go out without a mask, okay? Ngayon po, let's go to the next slide on the raffle of cases. May raffle po ba tayo? Starting with the MECQ. Now, transitioning to the GCQ, meron na po tayong regular raffle, no? But the raffle, please do not worry about us. We are doing our raffle via video conferencing or electronically. So minimum po yung face-to-face interaction namin, no? And then, what about court actions? As I already mentioned, they are extended, no? Unless, of course, that urgent action is required on certain matters, then hindi na po natin ipapasok yan dun sa extended periods. Aaktuhan na po natin agad-agad, okay? Next slide, please. Now, what about hearings, no? Of course, in ECQ, everything was suspended except for urgent matters, like habeas corpus petitions, amparo petitions, iyan po, kahit ECQ tayo, hini-hear po natin yan, no? But now, when we went to MECQ, nagkaroon na po ng issuances ng Supreme Court natin about video conference hearings, and nagkaroon na po sila ng Microsoft Teams, I think 365 po ang tawag nila sa application na yon. So now our courts, at least the pilot courts, are able to do hearings on all cases na po, is my understanding, civil and criminal alike, no? Pero doon po sa ating courts that are not pilot courts, hindi po sila kasali sa nabing application. Maybe the stations are not yet electronically equipped or there is no connectivity. Ang inaalaw po sa kanila is urgent matters, no? Kasi still, our priority is everyone's safety. Kung hindi naman po urgent matter, maybe we can set it at a time when we can already be safer. Okay? Okay, and then hearing through video conferencing is the next slide that concerns the PDLs. Sa criminal cases po natin yan, no? Pero ngayon nga, with the GCQ, we are extending it to all matters, even civil matters. All right. Okay, we'll show the slide on the Microsoft Teams application para alam nyo lang po what the courts are using now, no? So, we have tried this in the Court of Appeals also. This is how we do our raffle now. Okay. Now, let's go to reception of evidence. Of course, the judge has to be the one to receive evidence. Okay, the only exception there is if we allow ex parte presentation of evidence, no? So that may be delegated to the branch clerk, but the branch clerk has to be a member of the bar, so a lawyer. So hindi po pwede mag-ex parte presentation before non-lawyers. So kasi I have to repeat this over and over again kasi dun po sa ating first level courts, pwede po maging branch clerk ang hindi bar member, no? So, kaya inuulit-ulit ko po, kung hindi po sila abogado, hindi po natin pwede i-delegate sa kanila ang reception of evidence, okay? And then next, now let's go to our flow chart again. We are already at the offer of evidence part, no? Okay, the next slide, oral offer of evidence. Okay, so under the revision of the rules on evidence, all offers of evidence must now be done orally, no? If it's the offer of the testimony, you have to do it before the witness commences his testimony. Now, because of the judicial affidavit rule, you know that you have to state the purposes for the testimony before the witness commences the identification of the judicial affidavit. Po kasi I'm of the view and I advise those who attend my MCLE sessions on JAR, I advise them to already include the offer of testimony in their judicial affidavit. I think it's more practical, it's faster also. Mahirap po pagka yung mahahaba ang offer ng testimony natin. Our stenographers are usually hirap na hirap, no, to get each and every word that you state, no? So better, di ba, if the offer of testimony is already in the judicial affidavit. Not only that, for better review also by your adversary, no, para mapag-aralan na po yung offer so that the proper objections can also be made, no? So isama na po natin ang ating offer of testimony in our judicial affidavits, okay? And then if it's object evidence, including documents, then you make your objection or you make your offer. Objections will be made after you have completed your evidence presentation. All right. Let's go to the next slide. I've already discussed that, the offer of judicial affidavits. Of course, just to remind you, under the judicial affidavit rule, you can object to either the offer of the testimony or the questions themselves, no, and the answers in the judicial affidavit. And if the court thinks that your objection is justified, then the court can take out those portions which are objectionable, no? So kaya importante po na bigyan kayo ng court ng pagkakataon to raise your options, okay? So judges, please, pag meron po tayong judicial affidavits at nandyan na po tayo sa trial part natin before the witness or the affiant identify and authenticate their judicial affidavit, bigyan po natin yung adverse party ng chance to object, no? Both to the offer of testimony and also to the questions and the answers in the judicial affidavit, okay? For all the reasons allowed under the rules on evidence, okay? So yun lang po yun, yung slides natin on offer of judicial affidavits, and then we have testimonies via video conference. No, well, this is just pursuant to the circulars on video conferencing hearings by the Office of the Court Administrator. Okay, and then we go back to oral offer of exhibits, just as a reminder to everyone, under Rule 132, Section 34, that no evidence which has not been offered, which has not been formally offered, will be considered by the court. Alam po natin, that is our rule. Again, remember the fact that you identified, authenticated, and marked your exhibit does not equate to offer of evidence, no? Kung hindi mo siya inoffer, baliwala po yung mga minark ninyo. Why is it like that? We are giving you the discretion, no? You may have identified it, your witness may have identified it, you may have marked it already, But in the end, when you're assessing, you think, I should not offer this anymore, then it's still subject to your control. Okay? Unless and until you formally offer it to us, then hindi po namin yan i-consider. Okay? Of course, you know that there are exceptions to this, pero very, very strict po tayo dyan. Okay? Now, when do we... No, okay, so here I have for you the rationale, no, for the oral offer of exhibits. Ang rationale po talaga dyan, no, is because, yun nga, because of the delay that is occasioned by, you know, by waiting for the formal offer, written offer, and then the written objections, etc. And there is really no practical reason for putting it in writing. No? Why do I say this? Kasi the counsels are present during the trial, di ba? When these evidence are presented, they've seen it and they know the purposes for which these exhibits are offered. The judge is also there when all this presentation of evidence happens, no? So lahat tayo alam na natin yan. So actually formality na lang to, no? Because this is required by our rules on evidence and because we want to respect the autonomy of the parties to choose which evidence they want to offer in the end. So as a reality, just tell us, alin ba dito sa mga prenisenta nyo na, minarkahan nyo, ang ino-offer nyo sa amin. Okay? So, kaya hindi po yan dapat mahirap. No? Kasi even before, when I was a litigator, even before I went to pre-trial, nakalista na po yung exhibits ko. No? Dapat ganun po tayo ngayon with more reason because when we file our initiatory pleading, nandun na po lahat ng ebidensya natin. So, this should not be difficult. Now, some judges asked me, Judge, mahirap naman tayo, lalo na kung maraming exhibits. Mahirap daw for judges also to do their oral ruling, no? Sabi ko, yan marap. It's just a system, no? We just do the work ahead of time. Alam naman natin na kung ano na yung minarkahan nila. 'Di ba? So nakita na natin yan lahat, no? So alam na rin natin at aralin na natin. Kasi alam naman natin sa flowchart natin, sa schedule of trial natin, when the last day of presentation of evidence will be for either party. So alam natin, on that last day, they will offer their evidence already. Kaya kailangan mag-prepare na tayo, mag-aral na tayo. But this is my practical suggestion, okay? To the lawyers, okay? When you are going to do your oral offer, make your own list already in writing, give a copy to your adversary, give a copy to the court, give a copy to the stenographer, para lahat kayo all on the same page. Okay? So that is just an advice, but I think it's a practical way of doing this para hindi po kayo mahirapan. Okay? And then, when do you raise your objections to the oral offer? You raise it also, no? There, right there and then, no? So, ang sa judicial affidavit rule po natin very specific to. Nakalagay doon, after every exhibit is orally offered, there will be an oral objection and the judge is supposed to make an oral ruling. Yun po ang tamang way na gawin natin to. Let's say you have 10 exhibits. If I'm the plaintiff, I orally offer exhibits A to J, no? And then, doon pa lang magsasabi ng objections yung adversary ko to my exhibits A to J. Di ba mas magulo yon? Kasi ngayon iisipin ng muna, ano na nga ba yung exhibit C na yan na ino-objectan, di ba? So, but do it sequentially. So, oral offer, exhibit A, oral objection, exhibit A, oral ruling of exhibit A. Mas magaling, mas madali, mahirap, hindi mahirap sundan. Okay, so that is what is in the judicial affidavit rule, and I think it is a very practical way to go about this as an advisory to our judges. All right? Okay, and then the next slide is just a quote from the judicial affidavit rule. I already discussed that with you. Then, when do you make objections to documentary and object evidence under the judicial affidavit rule? Ganun din po, na-discuss na natin yan. Now, repetition of objections a continuing objection. Yan po yung sinasabi natin continuing objection. No? So, it's enough for you to register that continuing objection only once. Do not have to keep on standing up while this line of questioning is being provided by your adversary. Okay? And then ruling on objections, ganun po, as I mentioned, although wala pong categorical dun sa ating revisions or rules on evidence on an oral ruling, no? I fall back on our jar. There is an oral ruling by the court, no? After immediate, there is an oral offer and an oral objection. Okay? And that is found in Section 8 of our Judicial Affidavit Rule. Okay, now let's go to the striking out of the answers to questions. Okay? Ito po, binigyan lang tayo ng reasons when you can move to strike out answer. The first will be if the adverse party was not given a chance to fully state the ground for the objection, tapos sumagot na po agad yung witness. Alam na po natin yun, no? Or, for example, the answer is not responsive, the witness testifies on a question which is not posed, no? Hindi naman yun yung tanong, no? So not responsive nga. Or testifies beyond the question that was posed, no? So lead na po siya. Or, for example, the witness does a narration when a narration is not called for. And for other grounds, no? So, yan po ang mga grounds natin for striking out an answer. But of course, we are also aware, and I hope yung ating mga new litigants, new lawyers will not expect the courts to really strike out something from our records. No? So when we say strike out, hindi po talaga natin strike out. We just put that note in the record, it's in the TSN or in the actual record of the court, that the court granted the motion to strike out. And this is for the reason that we are preserving the entirety of the record for review later on by a higher court, whether on appeal or via other modes, no? Okay, and then we go to tender of excluded evidence. We know this, no? Pero kasali po ito sa trial. You may wonder, teka muna, hindi tayo evidence ngayon, simpro tayo, justice. Pero kasama po kasi ito sa ating trial part, sa ating flowchart, no? So, tender of excluded evidence, if any of your evidence have been excluded by the court, no, you can still tender it for purposes of review by court by offering it and attaching it to the record. Okay? Hindi po pwedeng tanggihan ng court yung tender of excluded evidence. Okay, now let's go to demur to evidence. All right. So, nandito na po tayo sa stage natin. The plaintiff has completed the presentation of its evidence. The defendant wants to demur to the evidence under Rule 33. Okay? So, after the plaintiff has completed the presentation of his or her evidence, defendant move for dismissal on the ground that upon the facts and the law, the plaintiff has shown no right to relief. No? So, ito pong demur to evidence, this is always by motion. So, kailangan po ang defendant ang mag-file na motion. And of course, this is a litigious motion. Okay? So, let's go to the next slide. Again, caveat, the order denying the demur to evidence will not be subject to appeal. Bakit po? Kasi kung dinenay po ang demur nyo, ibig sabihin, magpe-present ang defendant ng evidence, tuloy pa po ang trial. So, appeal is not proper kasi interlocutory lang po yung order of denial. But, can you file a petition for certiorari to quell that denial? Hindi po. Okay, sorry, we are removing this interlocutory relief. Ang gagawin nyo lang po is proceed to trial and then judgment on the merits, and then on appeal, you can assign it as an error, all right? And then, what's the rationale for a demur to evidence? It's there for you, but in plain and simple terms, it saves everybody time and expense. Kung hindi na kailangan mag-present ng evidence kasi hindi naman na-discharge ng plaintiff ang kanyang tinatawag na burden of proof, because the evidence presented by the plaintiff do not amount to a preponderance, then we can file a demur to evidence so that we can end litigation at an earlier stage. Okay? So the next slide also is a quote from Radio Wealth. That is a continuation, no? And then the next slide. Okay, so that's just that is the old rules, no? Yung certiorari in case of grave abuse of discretion, but because of our new rules, hindi na po natin yan i-allow. Okay, so next slide shows you the steps, no? Because when you file a motion to demur to evidence under Rule 33, it is a litigious motion. So you must follow the steps, no? First, personal service or service through an accredited courier or registered mail or electronic means. So you need proof of service. Second, the opposing party must file an opposition within 5 calendar days from receipt of your motion. Automatic, do not wait for the court to order you to oppose, okay? And the third, the court within 15 days from receipt of the opposition or lapse of the period to file the opposition, the court must resolve the motion, okay? Unless the court decides to hold a discretionary hearing, in which case the court will issue the notice of hearing to the parties. Okay? Okay, now let's go to the flow chart again, just to remind and show everyone that now we are at the judgment phase. Okay. Okay, we are at the last stage. Okay, so the period to render the decision, we will follow the constitutional provisions. Now, on the next slide, you see it. The periods allotted by the court for resolving, or not resolving, but deciding. Okay, so clarify ko ulit, no? Kasi even the rule now, I saw, they said when it is submitted for resolution, no? Nainis ako nung nakita ko, I don't know how this escaped me, or if there was a change and I did not see it anymore, but this should have been from submission of the case for decision, no? I'm referring to Rule 30, Section 1, no? So ang nakalagay kasi submission of the case for resolution, no? Ayoko yun kasi yung resolution po, those are for interlocutory incidents, no? So mali po yan. That should be submission of the case for decision. Anyway, you know the difference between resolution and a decision, no? But what's the difference between a decision and a judgment? Because you may say, Justice Singh is using decision and judgment interchangeably. Wala pong difference, okay? They are one and the same. But ako, I always want to use the word decision as the title of my work, okay? But I also often refer to it as rendering judgment, no? Kasi mas maganda pakinggan rendering judgment than rendering a decision, issuing a decision, or drafting a decision. Okay? Stylistic po. Okay, what are the form and contents of a judgment? Well, they're the same. Okay, so it has to be personally and directly prepared by the judge, stating clearly and distinctly the facts and the law. It has to be signed by him, filed with the clerk of court. No? So, ganyan po kahit po sa amin sa Court of Appeals. It is a judgment once we, and will be promulgated once we hand it over to our DCC, our Division Clerk of Court. No? So, paulit-ulit po ang Supreme Court sa atin about stating distinctly the facts and the law, no? So bawal po yung tinatawag natin na mga decision na memorandum decision na wala pong discussion ng mga facts, okay? All right. Next, we have judgment for or against one or more parties. Judgment may be given for or against one or more of several plaintiffs and for or against one or more of several defendants. When justice so demands, the court may require the parties on each side to file adversary pleadings, etc. No, ito lang po yung pagka multiple parties tayo. Halimbawa, plaintiffs or multiple defendants. No, so you can, the judgment can be for the plaintiff, for all the plaintiffs, for only for one plaintiff, etc., etc. Okay, let's go to the next one. Several judgments. In an action against several defendants, the court may, when a several judgment is proper, render judgment against one or more of them, leaving the action to proceed against others. Pwede po yan, no? Kung halimbawa, yung isang defendant, may sarili siyang sagot, pero yung defendant na yun, inadmit niya po yung mga material allegations sa complaint, no? So, pwede na tayong mag-judgment on the pleadings as against this particular defendant. Pero as against the other defendants, kung meron po silang valid defenses that raised genuine issues, then we should proceed to trial as far as those defendants are concerned, okay? And then separate judgments, when more than one claim for relief is presented in an action, the court at any stage may render a separate judgment disposing of such claims. Ito po yung sinasabi natin, meron po tayong mga cases na may two parts, no? Like for example, yung expropriation proceedings po natin, although that's not an ordinary civil action, no? So meron po siyang dalawang part. Yung first is the determination of the right to expropriate, no? The existence of that right, the exercise of that power. And second is the just compensation part, no? Ganun din po sa partition. First is the determination of who are the heirs who should participate in the partition, no? Is there a co-ownership that exists? And then the second is the actual partition proper. So yun po, separate judgments yun. So pag na-determine mo na yung first part, that's a separate judgment. Judge appeal yung parties from that. The second half is still pending, no, in the original court, no. Yun po yung separate judgments na tinatawag natin. Okay. Now let's go to entry of judgments and final orders. Okay, eto na po. If there is no appeal or motion for new trial or reconsideration, within the time provided by the rules, the judge or final order will be entered in the book of entries of judgments. Lahat po ng courts natin may book of entry of judgments. Hindi lang po magkakapareho ang itsura nila, but we all have this. We're all required to maintain one. Okay? Now, the date of the finality of the judgment or final order will be deemed to be the date of entry in the book of judgments. Kailangan po ba i-physically enter yan? Or pwede na po bang i-print na lang yung decision at i-attach doon sa book of judgments? Every time I do our orientation of new judges, I remind them, hindi po ninyo dapat gawin yon. Mag-print kayo at i-attach niyo yan sa book of judgments niyo. Or gupitin nyo lang yung dispositive portion tapos i-attach nyo yun sa book of judgments nyo. There is a reason po why we want you to physically enter it in our book of judgments. And that is a safeguard. No, that only the branch clerk can do that. There will be no other individual with intent who can enter a judgment in that book. Kaya po yan, it is a very civic duty on the part of the branch clerk. Okay? And then, of course, a reminder lang po to all our judges who may be listening today na pag ganyan po, nag-enter na po tayo, issue na po natin ang ating certificate of finality. Please do not wait for the winning party to come to court to ask for a certificate of finality. Gawin nyo na po ito at tiin na siya. No? Do not wait for a party to ask for it. Okay? So, this is the end of our second module, and I think now we will go back to the Dean for our questions. Thank you very much. Okay, so Dean, Marisol, we are now ready for the questions. Well, I'm not sure, but maybe I should just go ahead. I have with me the questions asked from yesterday's session. So I'll go ahead and read them and then give you the answers, okay? So stop me if that is not the flow of program that you want, okay? I just don't want us to waste time. So the first question asked is, in the new rules, meaning the revised rules, do all the documents be submitted to the court have to be the originals, okay? And will the case be dismissed if the originals are not submitted? The answer is no, they do not have to be the originals. Even the judicial affidavit rule allowed you to attach photocopies. And specifically now with our rule on pretrial, yung Rule 18 po natin, if you remember earlier, you are required to bring the originals during the pretrial and you will do the comparisons there. So hindi po kailangan, okay? Number 2, is including your email in the signature page equivalent to consent received your email address, or do you need another consent form in order to serve parties via email? Ako po, para sa akin, enough na yun. Kasi why else would you indicate your email address if you do not intend to be served via email, no? Pero kung gusto nyo po, just to be very clear about it, no, you can have a statement incorporated in an order to be issued by the court. Now, for example, you say that the defendant's counsel and the plaintiff's counsel have both consented to be served by electronic means or via email. Okay, next question. Under Rule 8, Section 6, what is meant by authenticated copy? No, that refers to the copy of the document together with the apostille certificate emanating from the Department of Foreign Affairs. Yun po ang meaning ng authenticated copy. Number 4, in what instances may the court obtain motions to dismiss under the new rules? No? As a general rule, motion to dismiss is prohibited, allowed only in 4 instances: lack of subject matter jurisdiction, litis pasha, res judicata, and prescription. Otherwise, you raise your affirmative defense in your answer. Okay? Next question. Under the new rules, it expressly stated that the authorization of the client to act on behalf of a party for verification and certification of non-forum shopping should be attached to the pleading. Does this abandon the rule that certain officers need not attach their authority in order to make the verification and certification of non-forum shopping valid? For example, the president, yes. My answer is a definite resounding yes, no? Kasi ito na po ang last expression of the will of the Supreme Court, itong revision na to. So subsequent to that jurisprudence, in-issue po natin to revisions na to. So ito po, we deem this to be the Supreme Court's rule, latest rule on the matter, all right? Next, Rule 14, Section 3 states that where summons is to be served outside the judicial region of the court, where the case is pending, the plaintiff shall be authorized to cause service of summons. No? Does the plaintiff still need to be assisted by the sheriff in this case? If it's outside the judicial region, natalo po kami sa debate na to, kaya outside the judicial region, hindi na po kailangan yung sheriff, no? Kasi masyado na po daw costly yon kung yung sheriff ng court outside the judicial region, ipapadala pa natin doon. But you know, one practical solution to this, if you want to be safe, if you want to be safe or to err on the side of prudence, is to have a coordination with the ex-officio sheriff in that judicial region. Pwede po, yun po ang ginagawa ko dati. So that can still be done. No? But if you do not do that, no, meron pa rin naman pong safeguard. No? Under Rule 14, Section 21 po natin, if the one who serves the summons is the plaintiff or the plaintiff's representative without the assistance of the sheriff, no, that person who served it, who is not an officer of the court, is required to file a return of service which must be under oath. No? So, yun po ngayon ang naging safeguard natin. Dahil it will be under oath, meron po tayong remedy sa kanya kung siya ay magsabit ng false return. Okay. I think I skipped number 6. The question is, are there any accredited courier services as of now? My understanding is that the Office of the Court Administrator is still drafting the guidelines. Kaya lang po na-overtake po tayo nitong COVID-19 na ito. Give the OCA a little more time and I'm sure they will come up with the guidelines soon. Okay, next question, number 8. Resummons. Do you know of any example of an international convention for the service of summons? No, I know that there is the Hague Service where service of both judicial and judicial documents in civil and commercial matters have been agreed upon, no, through a centralized authority which is authorized to receive on behalf of a party state. The only problem is hindi pa ho yata tayo nakaka-accede dito as far as I know, no? But we have already expressed the intent to accede to this convention. No? Number 9, with the new requirement that judicial affidavit should be attached to the complaint, how can one file a complaint if most witnesses are abroad and the original intention was to take their testimony by written interrogatories? You can still take them by written interrogatories under Rule 24, no? Yun po yung ating depositions before action. So you will already perpetuate their testimonies even before you file your petition para when you file your petition or your complaint, naka-attach na po sila. All right? And then the next one is, number 10 is the list of court email addresses released by the Supreme Court for purposes of electronic filing already under the amended rules? Or is it just for purposes of e-hearings during the community quarantine? Napilitan po tayo. We were all forced by the circumstances. We were all forced by the pandemic to resort to electronic means to continue our work. So ang Supreme Court po, naglabas nito mga circulars na to, nag-assign po ng email addresses, etc. No, but there is no reason for us to discontinue this, especially with the revisions under the rules. No? So now more than ever, kailangan na natin ito. Kaya itutuloy na po ang paggamit niya. Okay? Next, number 11. Can the court require both parties to file and serve by email? Or is it purely voluntary on the party? Ito po ang sagot ko dyan and I hope it's going to be clear. No? Ang nakalagay po sa rules natin, by consent. The parties have to consent. And I explained to you the reason why. No? Kasi hindi naman po tayo all similarly situated. Hindi po lahat may access sa internet. Hindi po lahat ay merong, marunong, no? Marunong gumamit nitong mga electronic means na to. So, kaya po ni-require natin na mag-consent ang parties. Pero kung they will unreasonably refuse, no? Like, alam naman natin may capability sila. Let's say that their office is in a major urban center, no? Tapos it's in a place na alam naman natin na meron po connectivity. So, yung pong ganong instances, pwede na po nang i-exercise ng judge ang kanilang control over the proceedings, okay? And then, number 12, there have been periods for judges and justices to resolve interlocutory incidents, but these are not being followed, thus causing delay. How is this perennial problem addressed in the 2019 rules? Okay? Unang-una po, kung meron po tayong mga judge or justices na hindi po nakasunod sa mga panahon or periods na inassign po under our rules and under the Constitution, meron po tayong remedy dyan, no? But I always plead for you to give us, members of the bench, allowance. Doon na po yung mga judges natin, napakalaki po ng mga volume ng cases na hinahandle nila, no? So let's try and be a little patient with them. Alalahanan po natin. Let's file a motion to resolve, no? Yun po ang unang step towards that. Pagka rin po, then that's when you resort to your other remedies, no? Pero naman po yata fair sabihin na they are not being followed as a rule. Hindi po ako naniniwala dyan. Mas marami po ang sumusunod, bihira ang hindi sumusunod. Okay? At ang natin dito sa ating new rule, pinaikli pa po natin ang mga panahon. Nakita nyo, yung solve po ng interlocutory incidents, yung pong ating mga litigations, no? 15 days. So, ang mga judges natin mahihirapan. Kaya po, intindihin nyo, yung ating mga practitioners, hindi lang sa inyo ang dagan ng konting trabaho, ang judges din po natin. Pero alam ko ang judges natin hindi magrereklamo. Susunod po sila because they all know that it's going their own benefit in the end. Okay? Thank you. And then now let's go to number 13. Under the most provisions expressly state that an order of the court are not subject of appeal or certiorari. Okay? However, can such order be subject of a motion for reconsideration? Thank you po at iliwanag nyo to. If you will note under Rule 5 on litigious motion, kasama po doon ang motion for reconsideration, which means pwede pong file reconsideration as a rule except in those instances where the rule clearly prohibits it. Gaya po nung sa judgment on the pleadings, summary judgment. Now, you will also cross-refer this to Section 12 prohibited motions. No? Under paragraph B, you have motion for reconsideration on affirmative defenses. No? So yun po, pinagbawal talaga. So yun po yung sagot sa tanong ninyo. Now, let's go to number 14. Since the provision on unsigned pleading was deleted, no? Tinanggal po kasi natin yan. What now is the effect of an unsigned pleading under the amended rules, no? Kasi po, sinakalagay po dati sa 1997 rule natin, it has no legal effect, no? So, alam naman po natin na yung unsigned pleading, that is a procedural or technical defect, no? So, kadalasan po, iyan po ay result ng inadvertence ng counsel or ng kanyang non-staff, no? Kaya napa-file po na walang pirma. So, kaya po ang ginagawa natin dyan, we just remedy the defect. It's not jurisdictional. Kaya po natin tinanggal, ayaw na po natin ng mga ganong mga interlocutor na makapagpapatagal. Now, the only po if that is what happens is for the judge to cause the party to in a multi-venue complaint, no, example, the properties in different jurisdictions involving the same parties, which court takes prior jurisdiction over all the others? Well, it will always be the court which first takes cognizance of the case. Yun po, the court which first takes action. Okay? That is assuming all the courts have jurisdiction over that subject matter and they are also all in the proper venue. Okay? Now, number 16, ito, when I was reading the questions earlier, no, natuwa po ako sa number 16. Pakinggan niyo po ito. Importante po ito. Under Section 3 of Rule 10, it is provided that an amendment by legal court shall be refused if it appears that the motion to amend ended for delay or to confer jurisdiction or when the pleading stated no cause of action at the outset, no? So yun po, you remember we discussed that yesterday. However, if amendment is an amendment as a matter of right under Section 2 of Rule 10, may the party still amend his pleading to confer jurisdiction or to state a cause of action, no? So yun po yung doon. And the answer is this, no? Yes, okay? Pwede as a matter of right. Yan, wala pa pong action na ginagawa ang court at that point. Okay? In fact, any change you do, the court is bound to admit kasi it's only amendment by notice and the court only confirms that you amended. The court can do no other action. No? So, pwede pa po. That is my view. Specifically, the rule very clear. Section 3. There's only amendments by leave of court. Yun lang po ang affected by these three limitations. Okay? Now let's go to number 17. In case of substituted service of summons, if a security guard of a count refuses to receive the summons, what can the ship do? Okay, unang-una po, hindi po pwede basta sa security guard, no? Ang nakalagay po dun sa new rules natin sa substituted service in a gated subdivision, it has to be the chief security officer, okay? Hindi lang basta security guard, no? And then, what you can do is to tender it, no? Ano po ibig sabihin ulit ng tender? You leave a copy in the presence of and within the view of that chief security officer. And then you put in your return that you tendered it because security officer present but used to receive it from you. Okay? And then in number 18, the amendments require that judicial affidavits of witnesses be attached to the complaint. To what extent does this limit the plaintiff's ability to avail of modes of discovery in particular non-party depositions, no? I already mentioned, no, hindi po nawawala yung utility ng modes of discovery natin. Nandyan pa ho sila, no? So pwede pa rin po tayo mag-resort to our modes of discovery. Okay, and then of course, if you will remember, doon po sa ating Rule 7, Section 6 on the contents of a judicial affidavit, di ba? Lagay po doon na those who do not have judicial affidavits cannot testify during trial. Pero may proviso po doon na for meritorious reasons, the court admit the judicial affidavit of other witnesses. Okay? So meron pa pong ganong proviso. Hindi, lagi ko ngang inuulit sa inyo, hindi naman po unreasonable or unbending ang ating mga rules. Okay? And then the next question is number 19. For through email, are we still required to send a paper copy to the court under Section 16D? But wouldn't that defeat the electronic filing? No? So hindi po, kasi ibahin po natin yung filing dun sa proof of filing, di ba? So you are using electronic means to file. Pero kailangan ko as the court yung proof ng filing mo. That is why we are requiring you to print it out and to attach an affidavit of the one sending electronic means. Iyon lang po yung proof na filing mo nandun na. But we need to prove your filing. Those are two different things, okay? And then number 20, should the enumeration under the significance of counsel's signature be written on the pleading like what's being done in attestations in judicial affidavits? No need. Okay, no need. Nakalagay sa rule natin, it is a certificate of those things, but you do not need to state it. That is understood. That is already in the rule and that is deemed read into your signature. Okay? So kaya kung akala po natin, hindi natin yan nilagay doon, hindi na yan kasama sa mga ina-attest natin, mali po kayo. Every signature of a lawyer will now be deemed a certificate of all these things enumerated in the rule. Okay? Next, for a party who wants to file a complaint with the TRO, especially a 72-hour TRO, the requirement to attach the judicial affidavits and pieces of evidence to the complaint would be hard to comply with and would result in delay. Should the rule provide an exception? Alam niyo po, ako very wary ako of exceptions kasi yan po nangyayari nangyayari sa atin rule, and then we have an exception, and then we have an exception, no? Wala na pong katapusang exceptions. Kaya po ang nangyayari, nababaliwala na po yung rule. No? Ang tingin ko po, ang solution ninyo ay ito. Even under the jar, you can also submit you were already required to submit judicial affidavits even for interlocutory incidents like an application for a TRO. So matagal na po itong rule natin na to. Hindi pa na po ito ng matagal ng Supreme Court. Kaya hindi na po natin matatawaran ang wisdom behind it, no? Alam niyo po, halimbawa may nangyari po na kailangan nyo i-TRO, no? Hindi naman po yun nangyari ngayon i-TRO nyo na agad bukas at ipa-file nyo na yung complaint. Well, sometimes that can happen. If it's really that urgent, then the person asking for this relief should be ready to support their claimed relief, no? Ganun lang po yun, no? We all need to do this sometimes. We pull all-nighters, no? So, hindi naman po kayo mawawalan ng remedy kung meron kayong justifiable causes. The rules will allow meritorious reasons to submit the other affidavits, no? Basta ma-justify nyo po sa court. If not attached to your reading, no? As I already mentioned earlier. Okay. Next, number 22. In anticipation of e-filing, are digital signatures on pleadings now allowed? No? Ito po yung tinatawag natin na other electronic means, no? Actually, sa ating rules on electronic evidence, meron na po tayong provision for this. Pero bibigyan ko lang po kayo ng konting cautionary advice, no? Take it slow when it comes to technology sa ating mga husga, sa ating mga judges at mga justices medyo nag-a-adjust. Bigyan niyo po kami ng konting panahon and we will catch up to this, okay? But definitely, yes, nandun na po yan sa rules on electronic evidence. Okay, 23. How will the court resolve situations where there may be a frequent change of email addresses, since this may happen affect validity of service by electronic mail? Are there any existing sanctions related to the court? Medyo hindi ko, I think ang point niya is baka parang to service ng palit ng email address, no? So, I think yung rule po na regarding notifying the court about the change in email address is enough of a safeguard, no? Kasi if you do not notify the court of your change in email address, then our service on your email address record will still bind you and will be valid service, no? So I think that's sufficient safeguard. Okay, next. Number 4, email service. Should the pleading be in Word or PDF format? Wala pong distinction na sinabi ang rule, binibigyan po namin kayo ng allowance. O kayo na po ang pumili. As long as it is received and it is readable. Number 25, for pleading served through registered mail or courier, is the affidavit of service required to be attached already to the same pleading that is being filed in court, or is the affidavit of service necessary only if receipt is being questioned, no? Ito po ay ating proof of service, kaya kailangan po naka-attach yan. Do not wait for somebody to question the receipt of your pleading, no? Lalong-lalo na po, hindi po aaktuhan ng court ang mga submissions nyo, lalo na, for example, it's a litigious motion, tapos wala po kayong proof of service, hintay nyo pong may mag-question, hindi na po pwede yon because that is required. When proof of service is required, then you need your mandated proof of service. And the affidavit of service is a mandated proof of service in almost all our modes of service, okay? And then the next question is 26. In apostillization, a convention, can the certification required be acquired from DFA's regional offices? Ito po, I have to say, hindi ko po alam. I don't know. I have not had a chance to inquire from DFA, okay? And then, with me, hindi ko po alam ang sagot dyan. Okay, and then the next one is, number 27, what is the acceptable proof of consent of the other party to allow resort to email? And does the revised rules require the subsequent submission to the court of proof of filing of the email? To the first question, I already answered that. No, it will be best if there is something in the record, whether it's a written manifestation of the party or an order of the court which records the consent given by the parties to be served by email. Now the other question, do you need proof of filing by email? Of course, kailangan po ang proof of filing. All right? And then number 28, is it to state that Friday is now exclusively for hearings of litigious motions and need to include in the motion filed or submitted the time and date of hearing? Ay nako, hindi na po natin kailangan ng notice of hearing, no? That's one big revision under motions. You are no longer required to motions for hearing for the simple reason that now court na magdi-determine if there should be a discretionary hearing on a litigious motion. Otherwise, to stress, okay, if there is a litigious motion filed, then automatic within 5 days, the other party must file an opposition. Okay, automatic upon receipt of the opposition or lapse of the 5-day period to oppose, the court must resolve the motion. Pero the court has a choice to the litigious motion for a summary hearing. Yun po yun. Pag nag-decide po ang court na iset yan for summary hearing, the court will be the one to issue the notice of hearing. Okay, so please, for motions, all you need is the proof of service. Okay? Now, number 29, will our courts be sending a reply to acknowledge receipt of pleadings filed electronically just to be certain of its success electronic filing? On court should do that, no? And if they do it, then that po nakalagay sa ating proof of filing, di ba? If the court issues an acknowledgement, then if not, the filing will have to be proven in that I discussed with you, in the method I discussed with you, the affidavit of the person sending the electronic mail, a printed copy of the electronic mail pleading, all right? And will the 2019 rules apply to filed before its implementation, where the summons remains unserved up to this time? Okay, so Rule 144 on the effectivity of the new rules or the revisions says that it applies, or it will apply, the revisions rather will apply to all cases filed from May 1, 2020 onwards. But they will also be applied to pending incidents on two conditions. Application will be feasible in discretion of the judge, and it will not prejudice any parties. So this will now depend on the judges. Okay? So ang advice judges natin, kasi baka magkakagulo yan, no? Lawyers will want to know. To my case was pending already at the time of the effectivity. So, siguro po, judges, you need to issue an order in your pending cases kung i-apply nyo po itong rules na to kasi it will be feasible, etc., etc. Okay? And then the last question is, number 31, in service of summons outside of the court's jurisdiction, there is no more coordination with the court in the jurisdiction of the defendant. No? I think ang ibig niya po sabihin yung na-discuss natin kanina, it's service outside the judicial region. No, if the plaintiff right, no more coordination with the sheriff, but for sake, no, and may presumptive regularity yung return, pwede po tayong mag-coordinate with the ex-officio sheriff in that other judicial region. But as I said, you are protected because the plaintiff who will file a return which is required to be verified or under oath. Okay, so that's the last of the questions that was sent to me yesterday. Thank you very much.
Thank you, Justice Singh. Those were the questions that were asked yesterday. And may I just say that answered it in 31 questions in 30 minutes. That's 1 minute per question. So talagang breaking yan, Justice. So sana ho you have more time because we have questions which is posted naman today. So I will be reading some of the questions that will be posted under the screen. So these are the questions that came in today.
Okay.
While I'm waiting for the question, may I just say, Justice, alam nyo bang magkaterno tayo kahapon? Magkaterno din tayo ngayon. Pero hindi tayo nag-usap.
Okay.
Just for the two lectures. Anyway, this is the
color
question.
code.
Yes, color coding. Okay, so what do we do if we encounter technical difficulties during an online trial? How do we prevent witnesses and counsel from communicating with each other during trial using separate apps and devices?
Okay, that's a funny question. Technical difficulties like yesterday and I got dropped several times, but waited and
Yes.
na-connect naman po. We have to be ready for that kasi talaga naman pong problema natin yan all over the country. Second, how do we guard against the counsel litigating with each other on different gadgets? No, we're not physically from doing that. No. We should operate under the presumption that just as the people trust the judges to do what is right, is honest, and what is fair, then we must also trust the lawyers to do what is right, what is honest, and what is fair.
I guess the court should also be equipped, electronically, at saka they should have a strong internet connection, or maybe have an IT person on call sa courts, Justice.
Actually, yan problem natin kasi that requires a lot of resources. So, ngayon kanya-kanya, the judges use their own gadgets. Kung pwede nilang gamitin yun sa office, pwede rin. But most of them have to put up their own internet connection also. So, yan talaga is our big problem.
Justice, this is the next question. What happens if a party fails to attach its documentary and object evidence to a pleading?
Then you cannot present it during trial. That is what the rules provide. Ang bagsik, no? No, but if you have justifiable reasons,
culture shock, Justice.
No, but if you have justifiable reasons, like I always say, then plead it with the court. Give the court a chance to assess your risks. Kung valid, then unbend, as I always say.
Party is still allowed to file a motion for external pleadings other than an answer? Parang nasa rules na yan, oh.
No, this is categorical, no.
Okay. Our next question regarding email filing under the Supreme Court Administrative Circular 39/2020 and 40/2020. Do we still need to comply with proof of filing? Examples under Center's Affidavit, filing, paper copy of filing, registry receipt, and mailer's affidavit.
Okay. With more reason to admit the required proof of filing, di ba? Kasi ngayon po, eliminate yung other modes of filing natin. Wala po tayong registered mail. For the meantime, wala po muna tayong couriers kasi wala pa po tayong accredited at lalo po wala tayong personal service. So, this is the only way we can double check that there was really. So, kaya kailangan talaga po filing. The fact that we are under ECQ or G or what have you does not suspend the rules. Okay?
Regarding non-litigious motions, under Section 4, Rule 15 in relation to Section 7, Rule 15, does the movant still need to serve the opposing parties copies of the non-litigious motion? If yes, will failure to do so be fatal to the motion?
Okay, if you read the provision, there is no requirement for service. Okay? So, kaya mo siya pwede invoke sa ground to deny the motion. Okay? Pero ang advice ko sa inyo, if it's non-litigious, the court will act on it, even in the absence of the other party because it will not prejudice party. Pero bigyan nyo na rin siya ng copy, no? Kasi parang, as a gesture of fairness, no? Para wala na po, mas makakatagal yan sa atin kung nag-issue ng court ng order, grinant yung non-litigious motion mo, tapos eto na yung kalaban mo, kine-question yung ginawa nyo, di ba? Hindi niya alam na may nangyaring ganon. Sir na yon para ma-avoid yung mga ganyang delay later on, bigyan nyo na lang ng copy. Hindi naman po mahirap mag-mail.
Minsan kasi matter of strategy din nila, Justice, di ba? Yung mga element of
Okay.
surprise na ganyan. Wala
Oo nga,
na.
oo. Ayaw na po natin ng surprises gaya nitong pandemic na to. Ayaw na po natin ng surprises.
Yes. Okay. So regarding other similar motions under Section 4H Rule 15, does an opposing party have the right to question the non-litigious nature of a motion?
Doon po sa other similar motions, yung catch-all natin, yung po, pwede nyo pong i-question kasi wala siya doon sa express enumeration. Okay.
Okay. So under Rule 15, for motions, I'll wait for it to be posted. Okay. So wala pa. But the next question, I can access it.
Okay.
So basahin ko isa. So under Rule 15,
go ahead.
for motions, can a movant still file a reply? What if the comment opposition contain any actionable document evidence?
Okay, no. If you read the rule on motions under Rule 15, only an opposition, no other submission is allowed. The court will consider no other pleading except the opposition.
Yes, okay. So regarding, motion day, Section 8, Rule 15, does the deletion of the phrase or if Friday is a non-working day in the afternoon of the next working day, under the old rule, does it mean that any postponement of a motion hearing must be rescheduled on the next succeeding Friday?
Okay, oo. Under the rule kasi Friday talaga ang motion day, no? Either morning or afternoon. But that rule also contains a colatila, no? Na nakalagay po doon unless it's an urgent matter that needs to be heard already. So pwede naman sa ibang day kung urgent.
So regarding the schedule of trial under Rule 30, what does termination of pretrial conference mean? Termination of pretrial, JDR or all?
All. Okay, if we're talking about scheduling the initial presentation of evidence for the plaintiff, we're counting 30 days, right? You count your 30 days from the last pretrial event. So if there was JDR, it will be the JDR. If there was no JDR, only CAM, it will be CAM. Okay? But for purposes of saying pretrial proper only, to issue the pretrial order 10 days from pretrial or conclusion of pretrial, we're just talking about pretrial proper.
Okay. So regarding action on demurrer to evidence, does the filing of a demurrer to evidence stall the party's 90-day period to present evidence under Section 1, Rule 30?
That is a very good question, no? Since the rule did not provide for it either way, no, then you can argue it. Okay, and let's see what the Supreme Court will say.
All right. So, who among the judges will get credit for JDR? The judge who originally handled the case, or is it the judge who conducted the JDR and who got the parties to settle the case?
Okay. Nako, did the judge ask this question? Okay, ganito po ang sagot ko dyan, no? If you mean by credit is who will be able to report it in their monthly report as a disposal, then definitely it's the judge who's handling the case. Okay? Kasi sa kanya po yung kaso na yon. Alright? But if you mean the number of cases settled by JDR, then I would have to say it's the judge who did the JDR, no? Pero hindi ko po alam kung may specific rule sa JDR niyan. Pero ganyan po ang alam ko as far as JDR is concerned, no? But sana po hindi na lang po yung credit ang tinatanong natin. Okay? Sana po ang isipin na lang natin is natapos po yung kaso na nagkasundo po yung mga partidos.
May a party still file an MR against any court action on a motion for judgment on the pleadings or summary judgment?
Yeah, nakalagay mention the rule to you, the rule on motions, litigious motions. Kasama po sa litigious motions ang motion for reconsideration, no? So which means na a motion for reconsideration of these incidents ay pwede. Pinagbabawal lang po ay yung motion for reconsideration dun sa affirmative defenses, which is very specific.
Yes. So since Okay. What happened to the meticulous PT conference where parties slug it out in open court to come up with the terms of reference that the judge will finalize?
Okay, dati po dun sa original proposal rules, revisions to the rules on civil procedure during the time of Justice Robert Abad, no, na meron po tayo yung terms of reference, no, kasi parang the idea was the parties themselves, no, they bring out all the issues during pre-trial and then they draft the reference themselves. Ito lang ang pag-uusapan during trial. Hindi po naman tayo nagde-depart from that, no? And we believe that with the filing of the initiatory pleadings with evidentiary facts already, together with the evidence, iyan na po ang mangyayari sa pre-trial natin. Mas madali na, mas maliwanag, hindi na po kailang nandun yung slugging it out during the pre-trial. Kasi doon pa lang sa initiatory pleadings, nakalatag na eh. Hindi na po tayo masyadong mahihirapan.
During the PT, parties can stipulate on the authenticity of documents. Would it be better for the parties to use requests for admissions to authenticate documents and only in case of disagreement take up matters during the PT?
Certainly. No, unang-una po, kasi nga naka-attach na ang ating mga documents sa ating initiatory links, pumapasok na po yung duty natin to make specific denials, right? Lalo kung actionable documents itong mga documents na to. So if you do not make specific denials of these actionable documents, automatic meron na po tayong admission, di ba? So dun pa lang sa stage na yon, exchange of initiatory pleadings pa lang tayo, na-eliminate na natin yung issue ng genuineness and due execution. Okay, now let's say na lumagpas tayo sa complaint and answer. Walang mga ganon, no? Kasi nagkaroon ng specific denial. That should not prevent you from filing a request for admission immediately after, no, to request for admissions of documents or facts. Pwede ho. Kaya nga sabi ko, yung modes of discipline, pwede pa rin gamitin, no? So tama kayo. We do not have to wait for the pre-trial to do these things. Resort to the modes if you think it will help you.
Okay, for our next question. Since the judicial affidavit has to be attached to the complaint upon filing, can it be prepared and filed electronically if the witness is abroad?
Okay. So ang preparation po kasi ng judicial affidavit natin under the judicial affidavit rule, nire-require yung examination face-to-face, di ba? So kasi po, this takes the place of the direct examination in open court. And the guarantee of truthfulness is in the face-to-face examination, di ba? So, kumbaga, transpose lang po natin yung direct examination to the office of the lawyer, no? So, kung gawa kayo ng judicial affidavit via video conferencing, no? Nasaan po yung ating guarantee of trustworthiness or reliability? So, yun lang po yung nakikita ko dyan. But of course, the Supreme Court will have to rule on this because this is going to be something that will have to be considered as an alternative, no, as a viable alternative, especially considering our circumstances now.
Kaya Justice, nagtatanong yung mga tao what happens to the modes of discovery? Can they employ that?
Yeah, pwede pa. Yes, they can use that, no, kung gusto nila to perpetuate testimonies.
Okay, practical question daw. How will parties be able to check the court records for cases where pleadings and orders were electronically filed and issued?
Okay, thank you. Kaya nga po natin sinasabi na yung act of filing nyo is different from the proof of filing. That is why we are still requiring you as proof of your filing, electronic filing, to submit the affidavit of service plus the printout para iyon po ang dapat naming ilagay sa record namin para makikita nyo kung ano yung mga tinanggap ng court by way of electronic means. Yan po yun.
Okay. There's a question on further amendments. Will there be amendments to the rules of summary procedure and the rules on small claims vis-a-vis the changes with the implementation of the new rules on civil procedure, especially in terms of timelines and deadlines?
Okay, I don't think I can answer that. We'll have to ask the Supreme Court about this.
Okay. Na, our audience yata are excited. Some changes that's
Naku,
happening just because, this is
wow,
really a
thank you.
big deal.
Okay.
It's really a big deal to see how fast they go with litigations abroad in other jurisdictions. So now it's very nice to see that it's actually happening here. So I guess in the next few months, we will see how effective it will be. But of course, we will expect that a lot of people will be adjusting, part of change. And that's part of progress. So Justice,
Yes, that's correct.
congratulations. That concludes
Thank you,
our
thank
question
you.
and answer. And thank
Thank
you
you.
for this because I've been hearing a lot of feedback. Also, your lecture was very clear, and I think a lot of people would really like to see how it will be applied in the practical sense because they're all at a loss how we're going to proceed. So thank you for giving light to that. Thank you,
Okay.
Justice Monet. I am that a lot of people would want to see a recording of this lecture, and also they're asking about your slides, your presentation. And I was thinking nga, the flow chart that you made, baka pwede may tarpaulin ka dun sa mga courts para yung mga iba, they can see at which stage are we already. But anyway, thank you
Oo.
very much. You are our first lecturer for our web lecture series, and I wish you luck on this on how we're going to be implementing this justice and also in your future endeavors. Thank you very much for your help. I get
Thank
everyone,
you,
all our
Dean.
audience are thanking you.
Thank you, Dean.
Thank you,
Thank you
Justin.
very much to the thank you very much to Daalay, to Nena and to Lala. Thank you to Attorney Mitoy. Thank you very much. Of course to Justice Robert Abad who really started all of this. Justice Robert, maraming salamat. To Chancellor Adolf Ascuna who's listening to us since yesterday, who's been listening. Salamat po, Chancellor. And to all my fellow judges, kayo po ang gagawa nito. Nasa inyo po ang malaking burden. Pero kayo rin po ang susi or key to the success of these revisions. So naman pong mga lawyers and practitioners, samahan niyo po kami. This is our way to go to the future on the wings of justice. Hindi na po wheels, kasi yung wheels na-flat, yung wheels tumitigil, nasisira, no? Pero yung wings po, mas mabilis ang paglipad. Samahan niyo po kami so that perennial complaint will finally be resolved once and for all. Marami pong salamat sa inyong lahat.
Thank you, Justice. We're happy to hear about everyone who's watching us. Chancellor Ascuna, I will see you po on June 18. We have a meeting. I would like to thank everybody who stayed with us this whole time. We finished our Q&A, and that concludes our first lecture. Thank you to Alay, to our chairman, Teddy Cruz, to our president, Nena Rosales, to our communications director, Attorney Mitoy Fernan Cayosa, to our corporate secretary, Joseph Nigrino, and Vic Drew, Dean Mel Santa Maria for helping us set this up. Very glad to know, Justice Abad is also a member of the Alaay and a very active in our board of trustees also. So
Yes.
with that, I'd like to thank all of you, and please watch our Facebook page for announcements on our next lectures as part of this web lecture series. Good afternoon to everyone. I have to thank Attorney Lala, who's there behind the scenes. Drew, also who's scenes. Thank you very much. And Vic, did I mention you? And everybody, our board of trustees who's supporting all of us and who's all watching. So please stay tuned, check our Facebook page and see what our next lectures would be. I assure you, everything will be very helpful in your practice and very helpful in your continuing education, so that we can be prepared with all of these changes that's happening in our community. So goodbye, thank you, and we'll see you soon.